So good morning. Welcome to the podcast. My name is Dave Holland from Results Rules OK. And I normally have interesting people joining me on these podcasts, as you know, and today's no exception. So don't worry, just relax. Today, great to have Mr. Jonathan Midgley, who's a partner of Cleveland Scott York, who are patent attorneys all over the UK, I believe. Jonathan, welcome. Please, for everybody listening in, just give a quick introduction, who you are and a bit of what you do.
Yeah, thank you, David. Yes, I'm Jonathan Midgley, and I'm at Cleveland Scott York. We do sort of help people to protect their intellectual property, so it covers all aspects of intellectual property, and I specialise in the patent side of the business, which is where people are protecting their innovations and their new inventions and that kind of thing. I've been doing this for 20 odd years and sort of came from an engineering background, and so I have that sort of technical background. And that sort of leads me into the sort of areas that particularly around electronics and telecommunications, which is the sort of area I specialise in.
Right, excellent. Okay, thank you. You may be able to hear the bell in the background because this is global headquarters. We're working from home at the moment, so the church bells are going. My apologies, but anyway. So great for coming on the call. Thank you. Now, what was my understanding, my observation, not being a specialist in patents and intellectual property, I come from a franchising background as part of my sort of experience, where it's very intellectual IP based. But for the people listening in, what is IP? You know, what qualifies as IP? How broad is this subject?
Yeah, I mean, IP is kind of a bit of a vague term, but it extends to cover any kind of intangible sort of concept that has some kind of value, and hence the sort of idea of property. So it can cover anything from having a great idea through to something that's a bit more tangible, like the sort of things that we register, which are sort of patents and trademarks and registered designs. But it covers things like copyright, of course, is another one. And copyright's quite nice because you don't have to do anything to actively record that, so that happens automatically. Whereas other rights, like the ones we deal with, which is patents and trademarks and designs, you have to actively register those at a patent office to get that protection put into place. So again, together, all these sort of things form this sort of body of things called intellectual property that you know have a sort of an intangible value, and often for businesses can be absolutely critical. You know, you invest vast fortunes in R&D to produce new products, and all that sort of intellectual effort that goes into that, and the time and money, you know, results in these sort of things that aren't necessarily things that you can easily protect. You can't lock them in a cupboard because you've got to sell them. And you can't really keep them secret in the main because your competitors can see how they all work and dismantle them and reverse engineer them. So this sort of legislation is put into place to protect these ideas and allow you to register that sort of protection, and that's where the patents and trademarks and designs come from.
So really, from a small, medium-sized company perspective, this could be anything that is I'm guessing now, sort of an idea or a design or a process or a system of some sort that is, I suppose, reasonably unique. That is IP. That's intellectual knowledge-based property then.
That's right. Yeah. So I mean, certainly on the technical side, and any kind of innovation that's you know has got some sort of value, then it has the potential to be protected. And there are some basic requirements. It has to be new, and it has to have some kind of non-obvious, you know, surmounted sort of contribution to what's already known. Okay. But of course, the other side of this, particularly on the say trademark side, is the branding side. So again, that's not so much on the technical side, but it's very much a critical part of the business, is that value you build up in your name and your product names and all those sort of things. And again, you know, not something you can easily protect against other than through these sort of registration of these rights.
So I mean, do you find just in your experience that plenty of people out there in business world, whether they're in your speciality for electronics, if you like, but generally they don't realize they've got IP that should or could be protected? They just create stuff but don't protect it well enough. Is that in general true?
Yeah, I mean, there's a lot of misunderstanding about what can be protected and what should be protected, and equally, there are lots of things that are out there that perhaps get protected that perhaps isn't so essential to protect. At the end of the day, particularly on the patent side, it's essentially an insurance policy to protect you against people copying your ideas. So if you invest a lot of time and effort, and then your competitor immediately goes, "Thanks very much, I'm going to produce something the same as that," then they take the idea away. The patent gives you the ability to have a limited monopoly and patents last for up to 20 years, and it gives you that right. So and the classic example is obviously the pharmaceutical industry, where they invest billions developing drugs, and if they produce them and then somebody copied them the next day, nobody would do it. So they get this 20-year period in which they can recover some value to repay and recover the cost of the development.
Sure. So if I'm running my company, I'm listening to this conversation, and I've got an idea or a system or a process that I think that is unique and different and valuable. What do I need to do first? How do I protect myself and my company? What's the first steps I should take?
Yeah, I mean, the first stage really is to identify those sort of innovations. Again, looking at the patent side of things, that's one of the biggest challenges. People are so busy creating and developing and taking products forward to market and then marketing and selling them, they sometimes forget about this sort of value that they've created, and that there might be a need to protect them. And of course, there's an endless balance between just going ahead and marketing the product, getting onto the market, but also getting that protection in place. And that has to be done very early, because in order to qualify for a patent, as I said, it has to be new, and it's judged against everything that's in the public domain at the time of file application.
Sure.
If you've given the idea away to all your competitors and then you try and protect it, it's too late. And so that need for that patent protection to be put in place needs to be done very, very early in the process, really, to avoid the possibility of it leaking out and becoming sort of detrimental to your own application.
So is the best time to do this, if you have an idea or a thought, you're going to do something, if you like, is it best, can you sort of start the protection from day one? Is that the best time, or is it to build it first, then get protection?
Yeah, I mean, again, there's a bit of a sort of a dilemma there, because in theory, as soon as you come up with the idea, you can protect it. You don't have to have a prototype, you don't have to have a working product. But what you do need to do is to be able to describe the invention in sufficient detail that somebody else can understand how to do it. So if it's not a fully formed idea, and you file your patent application, there might not be the sufficient detail. And this is part of the quid pro quo. You get your 20-year monopoly in exchange for telling the world about how your amazing invention works.
Right.
And so there's this requirement that it has to be sort of sufficiently detailed. So what people tend to do is they'll have the idea, the light bulb moment lying in bed or in the bath or whatever it might be. And then at some point, then they'll start to develop that idea. And usually when they've got a bit of a sort of maybe a prototype in place or initial sort of, pulling together of those ideas, that's the time to start with that patent protection. And then you can then move on to start talking to suppliers and potential customers to try and assess the value of the market. Because of course, it's fundamentally a very commercial product, and there's no point in having that insurance policy for a product that has no value or no commercial sort of prospects.
And I mean, I see used to see, I'm not sure if I see it quite so much now, you see on a product or something, and it's got patent pending, which is, I think was from the Wacky Races as well. But anyway, patent pending, does that mean anything? Does that give any protection?
Yeah, what that means is, and the reason why it says is because normally that's when you've applied for a patent application, and because the process tends to take a long time, that's your initial sort of stamp to say, there's protection in place here. Have a look, go and find out what it is that's out there that's protecting this product before you start copying it.
Yeah.
And normally, once the patent's gone through the process and has been allowed, you can then put the patent number on it. Normally, you'll then see a patent with a number after it.
Yeah.
And that's the actually defined sort of protection. But yeah, patent pending is still very legitimate, and it's something that we always recommend to clients to put that on there, because it's your sort of assertion to your competitors or anybody else that you are protecting this idea and you have value, you consider it to be valuable.
So if I've got this thing, this widget, this whatever it is that I've designed or had designed, and I put out the patent pending and the patent's in process, all this sort of thing, somebody pops up and they copy it anyway, because you say one of the I suppose the downsides, but we have to be visible with our ideas such that we can protect them, and somebody gets hot, they copy it anyway, they go off. What happens then? Where do I go? Is it hugely expensive? Is it very, how do I stop them doing it anyway?
Yeah, so I mean, again, once the patent protection is in place, that gives you that sort of right, and for 20 years you've got that ability to go to people and say, look, you're infringing a patent here.
Yeah.
You need to stop. And as long as obviously it's a legal process, and you have to assess whether they genuinely do fall within the scope of your protection. But if they do and they accept that, then they should just stop. Now, often it's not as simple as that, and there's a bit of discussion to go on. And that might be that you say to them, okay, you can carry on, but as long as you pay a license. And that can be a sort of satisfactory sort of middle ground. Or they may just dig their heels and say, no, we're going to carry on anyway. We don't think you're infringing, and we don't think you should have got a patent in the first place. And then you can start to get into a bit of argy-bargy. And usually it sort of progresses for a while, and ultimately may go to court, and the judge then decides the position. But usually at some point there's a settlement found, and some sort of happy mid-ground, either a license or a stopping. But in theory, if you've got a good, strong case, you can go to a judge and get an injunction to stop them selling there and then.
Right.
And ultimately, if you win the case and demonstrate that there's been infringement, you can recover compensation for loss of profits, or all the infringing articles can be delivered up to you to be destroyed. Okay. So it can be very powerful, and obviously the threat of that is meant to be a deterrent against people even thinking that copying. So the mere existence of the patent hopefully should be enough to deter people to sort of keep off the grass and not even sort of think about going down that route, or at least think very hard about what they're doing and making sure that they sort of do something that's a bit different. And generally, if you've got a strong enough right, people will then have to produce something that doesn't have the features of your invention, which might make it less commercially viable, or less good in terms of the quality of the product that you're selling to clients. So it gives you that commercial edge that again compensates you for the investment that you made in your R&D upfront.
So if I see somebody has got a patent out on something, some mechanism, something like that, and I said that's a great idea, and I copy it, or another company, but I change it a little bit by modify it, so it's not exactly the same. Is there sort of a degree of sameness that the courts would take into account, or how does that sort of work?
Yeah, and one of the big parts of what we do is we're sort of engineers by training, or scientists, but then we have to sort of learn this legal way of defining what an invention is. And the process really of that application is that discussion with the patent office to define the breadth of your protection. So if you're the first to market, so if you're the first person to create a DVD, for example, or a CD, you'll get very broad protection because it covers the very basic concept at a sort of very high level. So anybody who does anything that's sort of a shine disk that records data, you should be able to get protection for. And that's kind of where the first people start. And then usually you find there are refinements, and people will protect ever increasing, ever more refined little subtleties of a design. So it may come down to how the laser burns into the disk, and how you turn the laser on off and things like that. So it becomes much more subtle. So often you'll find one product might be covered by hundreds potentially of patents, particularly in some of these fields like DVDs and CDs and these things, and mobile technology. A mobile phone probably has hundreds, if not thousands, of patents covering various different parts of that product, which can make it really challenging to try and produce a product like that without inadvertently treading on some toes.
So if I'm again, I'm just thinking aloud now, but I'm thinking creatively, I'm designing a product or a service or a thing or a system, and I create this thing that I think is genius, of course.
Yes.
And how do I sort of check that it hasn't already been patented and protected? Is there somewhere I can go and say, here's my idea, and somebody go, yeah, well, that's already been done, don't bother, so I avoid the patent infringement? Is that possible, or is that a
to avoid infringement? I mean, there are databases of patents that are out there, and again, plenty of firms like ours that will help you to do that assessment and determine whether there is a potential risk. Right. And if then you identify that there's something that's quite close, you will then look at what protection that actually provides, what your product is, and whether you can modify your product, as I sort of talked about earlier, to try and make sure that you fall outside the scope of that protection. Ideally, hopefully, without sort of making your product too sort of hobbled in the process, so that you can still got a workable product, but without sort of then infringing that right. Or if it's sort of so fundamental, you might then sort of approach the company and say, look, we want to license this technology and actually use the ideas that they've got inside it.
And presumably, if somebody has a patent on a thing, a product, they don't ever have to make it or produce it. They can just go and sell license the IP and say, you go and build it. Give me, a pound of every one you use or make or something like that. That in itself can be an interesting business model for some people, I would have thought.
Yeah, well, and indeed, I think there are plenty of people who do that. Again, particularly for smaller inventors, it's obviously a huge investment and expense to build a whole company, to produce and manufacture products, build up a sort of sales chain and distribution and all that sort of thing. So you may have the best idea in the world, and this is one of the challenges we face when clients come to us. We're saying, well, okay, you've got a great idea, but how are you going to commercialize that? There's no point in protecting something that's commercially valuable if you can't actually get it to market. And so often the route they will then take is to find somebody else that's already got a sort of market in place and has already got the ability to produce prototypes and manufacture, and just license it to them, or arrange for them to manufacture for them. I mean, there's various obviously different things along the way, but the licensing model is obviously very powerful because it means you don't have to set up a factory, you don't have to set up distribution chains. You just say to somebody else, here's a product, and they go, yes, that's very interesting, we'd like to produce that, and we'll give you 5p a unit for your trouble, sort of thing.
That's it. I mean, I heard, you probably know a lot more about this, and I heard that I think it was the ring pull on top of a can of soft drink or something like that. Somebody invented it, and then they said they get 1.1 of a cent per ring pull that's produced. Is that true? I mean, it seems like a perfect model for your passive income. Is that true? Is that story true?
It does ring a bell. That, yes, I think so. I mean, obviously, again, that technology. If you think about the old ones that had that sort of teardrop shape, which is sort of ripped out and then it came loose, and of course the modern ones which retain all the parts, and obviously that's an invention in itself because you're not losing those bits and you haven't got those bits floating around in the environment or wherever it might be. It's all contained. Sure. So again, that might be considered to be sufficiently inventive on its own. And then obviously the actual way it was designed, with this sort of the tearable part, when you put the pressure onto it, it rips and opens up the can. So it is perfectly possible that, and if it was manufactured, or designed by someone who wasn't working for Coca-Cola or the beverage, company, then they may have gone, we'll talk to Coca-Cola and see if they're interested in doing it. And again, if it's a good enough idea, then those manufacturers might say, well, okay, we'll take it, but we'll buy it lock, stock and barrel. They could buy the entire right, whatever, £1,000, £10,000, £1 million, whatever it might be. Or they might say, well, we'll license it off you for 0.1 of a penny a time. And of course, something like that, you can imagine how many cans are sold around the world. It
absolutely. Yeah, you sort of hope it's true. You hope somebody's done that deal with the Coca-Cola, Diageo, whatever it is.
Yes.
But it sounds amazing. Sounds great. And is that something, again, as patent attorneys, is that the sort of thing you get involved with as well, as the commercialization of the patent, or not so much?
Less so. That, I mean, in terms of the legal side, there's sort of three elements to the profession. Certainly in the UK, in other countries it tends to be a bit more blended, but we're sort of primarily focused on obtaining the rights in the first place, and then once people have got the rights, assessing whether there's infringement and advising on that sort of stage. Then solicitors will tend to get involved in the legal sort of process when you actually start going to court, and again you'll get barristers actually representing you in court. So we tend to get involved primarily at the front end with the sort of obtaining rights and then the initial sort of assessment. Okay. But when it starts going into sort of court proceedings, we'll then sort of tend to get solicitors involved. Although patent agents do have right of audience to appear in some of the specialist IP courts as well.
Right. Okay.
And that does happen as well.
So if I get a patent, for my thing, and I come to you and say, look, you can get me covered, and it all goes through. Is that a global protection, or is it just in certain territories, or how does that work?
No, fundamentally, and this is sort of a bit of a frustration, but fundamentally, each country has its own system. So the UK will have its own system, America will have its own system, and so, if you want to get truly global protection, it's obviously a very involved process and very, very expensive. What tends to happen is people tend to focus on primary territories. So you might say, well, look, if I'm going to produce a mobile phone, if I can block off the US market so that no one can sell into the US market, then you've got to question whether it's worth somebody manufacturing a phone that they can't sell into the US or that's got to be modified to go into the US. And you might add to that, you can add sort of some of the European countries or Japan or China. And so by having sort of a selection of half a dozen countries, you can block off a lot of the world. And again, from that's the market sort of perspective, but looking at the manufacturing perspective, a lot of this technology is produced in China. So if you can block off China again, then it can't be manufactured in China, which might be more powerful actually, because then if you can't manufacture it cheaply in China, you've got to find another place to manufacture it. You may not be able to make it as good or as cheaply and that sort of thing. So usually you can get away with having a sort of selection of countries, and that's the typical model. People will pick a selection of maybe half a dozen countries of their main markets or the main manufacturing basis for those kind of products.
I mean, I saw, and the reason for that, the question was, I saw there's a video on a YouTube thing, and the Chinese have built, apparently, or it looks like it, what is a clone of a Rolls Royce, a car. And
Yes.
of course, it's not a Rolls Royce. They call it something else, but it looks like a Rolls Royce on some sort of bizarre steroid, But it's clearly, I say clearly, allegedly, be careful, allegedly copied. Now, if somebody over in China copies this thing,
Yeah.
presumably we're not protected in China. They can sort of do what they like, I assume. But when they come to import that product over to Europe, that's when the protection really kicks in, is it?
Yeah, that's right. And I mean, it can work in other ways as well. So, for example, something like a car will have lots of different elements of IP to cover it. So you might have trademarks to cover the names and things. You might have registered designs to cover the aesthetic appearance of the car.
Yeah.
You might have patents covering some of the technology within it. But also, again, if you imported something to the UK that looks very similar to a Rolls Royce or whatever it might be,
Yeah.
there are other sort of softer IP rights like passing off. So again, if you're selling a product and the public is going to be confused, thinking, well, I'm buying this product, it looks like a Bentley, so it must be a Bentley, it's clearly made by the Bentley company.
Right.
Then they're essentially the seller is trading on the goodwill and the good name of Bentley, okay, even though it's not made by them. And so Bentley can pursue them and say, look, there's a likelihood of confusion in the public. You're selling a product that people think or will be confused into thinking is associated with our company.
Right. Okay.
And this is a common law legal provision, and it goes back years and years and years. But that's sort of quite good in the sense that you don't have to seek any protection. You don't have to have a patent or a trademark or anything in place.
Yeah.
It's just a sort of unfair trading kind of regulation.
Right.
And the challenge, of course, is you've got to demonstrate that there will be a likelihood of confusion. That involves gathering a lot of evidence and showing people in the street, here's one car, what do you think who made this car, sort of thing. I mean, the other way around, of course, if it is happening in China, you wouldn't necessarily have that sort of passing off law protection, but you might have trademarks, you might have registered designs that you can protect in China.
Oh, really? Okay. So is that feasible? I mean, I on the outside, you hear all sorts of horror stories of China duplicating, cloning, all this sort of thing. Is enforcement genuinely possible over there, or
it's getting there? I mean, it's one of those things that's the big question, and for a long time, and it was cultural. I think in China, it wasn't considered, unfair or unreasonable to copy an idea. You saw an idea, that's great, and you make it. It's a business thing.
Sure.
And so I think there's in terms of international trade, though, it became sort of a problem, and I think there's been a lot of pressure put on China to do that. Now, the intellectual property system in China is actually pretty good, and the examiners we deal with there are very competent and do a really good job. And so what you end up with is, when you get a patent, is a really good quality product, in the sense that it's protection that's been validated and checked, and is of good quality. And the courts in China are, have gone leaps and bounds as well. There are now specialist IP courts out there with people, very qualified judges. So again, you can get a lot of the basic stuff in place. The challenge, of course, is enforcement. So you can have a legal decision, and that can be quite powerful. So again, if it's a car manufacturer, it's not like they can shut down and move down the road and set up again and just do it. So something like that can be quite easy to deal with. Yeah. It's when you're dealing with sort of low value, easy to produce items where you get your enforcement, you go and you try and shut them down, and so the factory's empty when you arrive. And then
there's a
week later they're appearing somewhere else,
and
they've come from down the road or in the next county or the next sort of state or whatever it might be. So that's really where the challenge is. So it's the enforcement side of things that is still a bit of a challenge there. But again, China's got some pretty good customs provisions as well, so you can actually stop stuff leaving through the customs checks in China. So if you've got trademarks in place and product is coming out that is clearly an infringement, you can get things stopped at the border. And you can do the same in the UK as well. As it comes into the UK, you can get customs. The customs authorities are very good at working with trademark owners.
Sure.
And they'll sort of recognise counterfeit goods, and they'll ask you to verify whether it's legitimate or not. And if it's not, they'll seize them for you.
I mean, you can't get a ham sandwich out of the UK at the moment, apparently.
That's pretty strict. Let alone some dodgy Ray-Bans, exactly. Yes.
Exactly. It's pretty good regulation. Pretty good regulation.
Yes.
So if I'm manufacturer, I've got this idea. What are some of the benefits? Just if I'm somebody listening to this, for example, might be thinking,
Yes.
well, I've got this idea. Why, why should I bother? Okay, I get it about the patents and protection, but what is the key things I should be benefiting from?
Yeah, I mean, the various different reasons why people choose to go for IP protection, and looking at the patent side of things, as we've talked about, obviously you invested this time and effort into this product, and taking it onto the market. So what you don't want is for someone to come and straight away and just copy the idea and compete with you, and having not made that investment, they can sell it perhaps a little bit cheaper,
Sure.
and you're sort of wiped out. So that's the main sort of reason why people tend to get patent protection. But as we talked about as well earlier, people do it often for licensing. So they may have come up with the idea just with the idea of licensing it on, and so that's the sort of next sort of big thing. But there are other sort of slightly sort of more unusual reasons why we do it. One of the examples is, particularly with startup companies, you've invested a lot of time and you've got a lot of know-how in the people that are working for the company.
Yeah.
And they might want to sell that company on, or do an IPO or something like that. And so at that stage, what have you got? You've got a bunch of people with, clever people who've, put together some products or services.
Mm-hmm.
But actually, if you sell the company, they could all walk away and you're left with this sort of empty office, basically.
Sure.
So when people are looking to invest, they want to see that there's something tangible they can actually buy into. And if you've got a portfolio of patents and trademarks that sort of underpin all that sort of know-how and branding that you might have created, that's actually something that's tangible. That even if people leave, they can't then take that with them because it's sort of held by the patent technology. So again, that sort of portfolio building to get asset value to a company, it can be quite powerful. And often, if people are investing, you've got capitalists looking in. They want to see that they're getting something, that they can actually get their claws into, as it were, in terms of securing something rather than just something that's intangible.
So if I've got this idea, I've got a 20-year patent applied to it. Is there it's just me thinking aloud now. Is there a strategy where I can, update the patent every 5 years? So I've got a stretching out 20-year program. It doesn't completely evaporate, or is that not how it works?
Yeah, no, that's absolutely right. And as I sort of said earlier, when you develop a basic idea, so I mean, the classic is something like the Dyson vacuum cleaner. They sort of came up with the basic concept of a cyclonic vacuum process. And so they get the basic sort of patent to cover that concept. But of course, as you develop the product over that 20-year period, you'll have all sorts of improvements, multiple cyclones, different methods of putting it together, battery operated, all those sort of things that might have a lot of time and effort go into them. And so you protect them. And of course, your competitors are trying to do the same thing. They're trying to sort of keep up. So if you keep innovating all the way along and add a new patent every few years, you build up this never-ending stream of protection.
Yes, it doesn't end. It doesn't stop.
That's right. Yeah. So yes, as long as you keep innovating, you can keep developing ideas. And the challenge is you can get companies who go through this massive sort of investment in creation and have great ideas, get some patents in place, and then sort of rest on the laurels for sort of 15 years.
Yeah.
And then suddenly all the patents fall away and all the competition comes in, and they're in real trouble there. So it's very important to maintain that innovation to keep your products moving forward. And that's sometimes where it gets forgotten. That you might have a culture that's very keen on patents. So initially, the company does very well. 10 years down the line, the management sort of structure has changed 3 times, and everyone's forgotten about all that sort of R&D that went into the initial sort of setup. Business is doing really well, really good, successful product, and that patent that's sort of tucked away in the drawer that hasn't been seen the light of day for sort of 10 years is sort of almost forgotten about. And then suddenly another 10 years goes by and the patent sort of runs out, and suddenly all these things start appearing in the market.
It starts disappearing. Again, presumably then there is a business model out there of these. I can imagine these hawks watching these patents count down the 20 years, and once they're out of protection, then they can produce what I would call a generic, if you like, or the aspirin, if you like. Everybody does aspirin now. I assume it's generic. Are people sort of sat watching? Is there a process of?
Yeah, definitely, watching? Yes. I mean, if you're again, aspirin's a good example with the pharmaceutical. All those generics companies are all sitting there waiting with their, their clocks ticking down, just waiting for that moment. And there's a whole plethora of legal cases about when you're allowed to start developing the product, because of course you can't launch on the last day of that 20 years. You've got to have your product ready to go. but you're not allowed to start sort of testing that and that sort of stuff. So there's all sorts of legal cases about people who have been sort of preparing and making preparations, and whether that's legitimate and that sort of thing. So yeah, no, very much so. And people have, there are services where you can watch patents that are in place and see if they're still kept in force, because you have to renew patents in most countries every year by paying a fee to the patent office. So it may be that somebody decides after 10 years that the product's not making much money, they're not worried about paying for that protection, they'll let it rot. So again, by monitoring the status of patents, you can say, oh, they're not doing that anymore. We can move into that market.
So they can lapse soon. You're going to keep the license and they can lapse.
Yeah, so the 20 years
before 20 years, not go over 20 years.
That's right. Yeah, 20 years is the maximum. Yeah, I mean, if you stop paying the fees, that's it. The patent sort of lapses there and then.
Right. Okay.
By the end of the year, the last fee was paid.
And so I think, again, just me thinking commercially, I see a patent that is it's lapsed. Can I go and get the drawing, the thing, and go, right, can I repatent it and for another 20 years myself? Or
no, because of what I said at the beginning, that this idea that any new application is judged against what's already in the public domain. So of course, once an idea is disclosed, and patents get published, after 18 months they're published, so everything that's in there is published.
Right.
So the idea is that information is now in the public domain, so you can't then re-protect that idea later on. So the only way you can make that work is if the patentee decided they didn't want to go ahead but wanted to sell the patent, you could buy it and get the benefit of the last 10 years. You become the owner of the patent, and you can get that protection. But you can't sort of re-protect it. And it used to be many years ago that you could protect it in another country. So if it had been patented in the UK, you could go to the USA and patent it there. But all that's gone. It's now a global picture. So
it's joined up now. It takes all the fun out of it.
Yeah, that's right. So it's disclosed. But yeah, I mean, again, the idea being that by bringing it into the country, you were sort of introducing technology into the country, which of course these days the internet does in milliseconds, whereas in the past it might have taken 20, 30 years for some piece of high tech in the States to come to the UK or vice versa.
Yeah. And so, and again, a sort of a phrase or a term that I've heard, but I don't know what it means, is a patent box. What's a patent box?
Yeah, the patent box is a UK government scheme, but there are different sort of equivalent schemes in a lot of other countries as well. It's essentially an innovation encouragement process that the government have, and so essentially, if you have a product that is covered by a patent, then you can the turnover from that product is treated differently for tax. So rather than paying 19% corporation tax on that turnover from that product, you pay a reduced rate of tax on that. So it's quite a nice, if you've got a product that's patented and is generating revenue, it's quite a good way of reducing your tax burden, and can be quite significant. Obviously if you're saving about 10% in terms of tax, and particularly going forward, the UK government are talking about increasing corporation tax. It may become even more significant for that as well. So it's quite a good way of trying to encourage people to protect their ideas and innovations. And in return for that, there's a tax benefit.
And I've come across, I know a couple of clients have done this. One client's an accountant, as you know, and what they do, they look at R&D tax credits. So if people are doing the research and development, the process of designing, developing something, there can be a tax benefit to that. As a technical question, would the cost of getting a patent cover done, working with you guys, for example, is that cost covered under the R&D tax credit scheme as well? Do you know, or not?
Yes, I think the scheme does allow IP coverage.
It does.
Okay. So often R&D tax credits and patent box sort of they're sort of two parts of the equation. So often people who are applying for R&D tax credits, you can use that to then get themselves a patent, which then protects that product when it's being commercialized.
Yes. Okay.
So those companies that are investing heavily in R&D and innovation, can benefit from both sides of that sort of equation.
So getting, I assume if it's a good product and it can sell, it can actually, getting a patent, working with you and your team, I'm going to say it can also pay for itself, because the R&D tax credit at the front end and a corporation tax credit or benefit at the back end, you're better off having the protection than you're not, effectively then.
Yeah, absolutely. And the patent just needs to cover some element of the product. So even if it's a complex product like a car, it needs to cover some portion of that, as long as that patent applies to that part. And so the patent doesn't need to be particularly the best patent in the world. Right. it can be sort of a fairly sort of simple sort of product, but as long as it meets the requirements that it's sort of innovative and new.
Yeah.
And so, yeah, for a relatively low cost, you can get a patent to cover that product. And and again, if it's a car, then that's obviously a significantly high value item.
Absolutely.
Which if you can reduce the tax on profit on that, that's obviously quite powerful.
Excellent. And so, and you're in the UK. We're set over here in Luxembourg, or global headquarters in France. Brexit obviously happened and is happening, and that sort of thing. Any particular big issues there that's affected the IP patent applications for you?
Yeah, I mean, it's created enormous confusion. The patent system, as I said, is national, although there is a thing called a European patent application, and it's managed by the European Patent Office, who have offices in The Hague and in Munich, in Germany, and also in Berlin.
Okay.
But that system has nothing to do with the EU. It's completely a multinational agreement that was put in place and has been for a long, long time.
Right.
And so it's unaffected by the whole Brexit situation. But of course, that's created a lot of confusion. People think, oh, UK is leaving Europe, yes. And therefore they're leaving the European patent system. So in actual fact, it's completely business as usual from the patent side of business.
Yeah.
The big change is the trademark system did have an EU trademark, and also the design system had an EU design. And so, of course, that applied to all the countries of the EU. What's happened to those is they've just split into two parts. You've now got a EU for the existing, the continuing EU countries, and now an equivalent UK right has been created. And going forward, you will need to protect in both those countries or those territories separately. So now, if you want to get EU plus the UK, you've got to file two separate applications to protect those separately. So again, that's the main change in terms of the EU aspect, is the trademark side. That's the sort of biggest impact.
Yeah.
But the patent system, has it's carries on as it was before, and really it's business as usual there, which is one of the sort of big confusions. I'd say it's everyone assumes that the whole patent system's been torn apart as well. But,
it hasn't. It's encouraging, I suppose. I mean, I think the Brexit deal, without getting into politics at all, I sense the Brexit deal will evolve over time. Things will happen, and things will be changed and adapted as we go along.
Yes, and as you said, it is very political. I mean, there were discussions about whether the UK might stay in this EU trademark system, but of course that's sort of political anathema because of the the sovereignty sort of aspect of the legal side of it. That was a problem in the UK, and obviously it being an EU body, the rest of the EU were obviously reluctant to have some third party sort of benefiting, from being in it, but not being in the EU. So of course, I think over time that might sort of change, and there might be some sort of more hybrid system where more countries, not just the UK, may be able to join that. And that's kind of what the EPO system for patents has worked like. I mean, bizarrely now you can use it, file a European application, get protection in Morocco and even Cambodia now. This is the European Patent Office, but they've sort of joined as a sort of they're not fully part of the scheme, but they recognise the European patent when it's granted. So it's sort of a bit of an expansion of that sort of system. And it makes sense because it's basically, although you still end up with individual patents in the countries, you file one application, and it goes through the whole process of examination and processing, and then it drops out as a European patent, which then breaks up into separate national patents.
Sure.
So it's quite an effective way, a cost-effective way of getting the sort of examination process done.
So it can still be done. So basically Brexit's happened, but it's still that coverage, and this is something that you can sort of wade through with your clients anyway, I take it.
Absolutely, yeah. And the bottom line is you can still get protection in the same territories as you did before, and if you had protection already, that still applies. So essentially business as usual. It's just sort of a few tweaks and twiddles that we sort of had to deal with to keep that sort of correctly ticking along.
So, okay, and thank you. I think the beauty of doing these conversations is that I learn a heck of a lot from everybody that comes on this way. It's great. So I really do appreciate. So obviously the thousands of people listening to this or watching this, I'm sat, I'm in the UK, I've got a company, I've got an idea, I'm doing something, I've got something that I believe may be intellectual property. What do I do? What should I do about it? What's my sort of first 2 or 3 steps? What should I do about this? Yeah,
I mean, the first thing, obviously, once you've got to that point that you think I've got something worth protecting, and you may have a little look around yourself, look on Google to see if it's a new idea. You can look at some of the patent databases. But really, at that point, you've got to say, look, if I want to get protection, I've got to talk to someone who can help me with this. And that's where patent attorneys like me come in. So people will give us a call and say, I've got this idea, what do you think? You know, is this suitable for protection? We will talk them through that sort of process. And if, you know, having had that conversation, that it looks like there's a prospect, we'll then sort of begin the next stage, which is really preparation of this legal definition of what the invention is,
Right.
a bit prior then to actually filing that at the patent office. But that basically from that initial contact, we'll take, you know, then our clients through that entire process right to the point at which they get their certificate saying, here's your patent.
So I mean, it sounds to me as if it's better to do it at the start rather than try and back it all in afterwards, if that makes sense. Start off, have the conversation as the process is beginning.
Yeah, it's one of these sort of, I say, slight problems, because of course the earlier the better from that perspective. That's always the sort of the sort of critical sort of thing, because once you file a patent application, you can then talk to people about it, and it won't affect your patent application.
Yeah.
Of course, the downside of that is that there is an expense and a cost to doing that sort of process, and obviously, particularly for small startups, you know, you're worried about sort of getting prototypes out, getting yourself marketed, and so an extra cost is not desirable. So there's a balance to be had, but usually, yeah, it needs to be done really as early as possible, and that's always the safest sort of time to do it.
Okay. So anybody listening to this, how can people, or what's the best way of contacting you know, Jonathan Midgley at Cleveland Scott York? What's the best way of doing that? What's your preferred?
Probably the best thing is just to go on our website. Our email address is on there. You can drop us an email or give us a call, we're happy to help people with you know, any questions that they might have.
Fabulous. And then you're on LinkedIn as well. People can sort of track you down on social media too.
Indeed, yes. Yeah.
Fabulous.
So yeah.
Excellent. Well, look, it's been a joy. It's been a pleasure. I think people are sat there listening to this going, oh my goodness, hopefully they've got something they know they can protect or should protect, and they need to, you know, jump on the email and just have a conversation with you. I know, and I knowing you as I do, I know you don't bite. It'd be good to have that sort of conversation to start the process off. So Jonathan, thank you for joining us and giving us all your pearls of wisdom. I'm sure that's been really helpul.
Pleasure. Good to talk to you.
My pleasure. And for everybody listening, please, you know, contact Jonathan Midgley is Cleveland Scott York, and just at least say thank you for the conversation, and reach out and have a chat. So Jonathan,
yeah, we're more than happy to talk people through, and you know, even if you've got a sort of a basic question, not sure what you want to do, what you should be doing. Often people ring and go, I've got an idea, I'm not quite sure whether I should be patenting it, trademarking it. And we're happy to sort of talk people through that process. And if they decide, you know, after a little conversation that it's not for them, then that's no problem at all. So yeah, we'll deal with all that sort of side of things.
Excellent. Good. Well, thank you so much. It's been a real pleasure. I'll be here probably next week with other people lined up. Maybe not as in-depth and technically interesting as Jonathan, but interesting all the same. So, Jonathan, thank you for your time. I really appreciate it. I'll be back next week. To everybody listening or watching, please, do Jonathan a message. Say thank you. Say hello. I look forward to updates, and I'll see you real soon. But for now, bye-bye. And Jonathan, thanks again.
Thank you. Good to talk to you.